Welcome to Fairly Competing, the show providing in-depth analysis of trade secret law and the law of non-competes and other restrictive covenants. Whether you're a business owner, CEO, in-house counsel, HR executive, or other employee, or a new lawyer or advanced practitioner, join us for a discussion on the latest trends and hot topics, evolving federal and state laws, key developments, and other emerging issues in trade secrets, non-competes, and employee mobility in today's knowledge economy. And now, here are your co-hosts, John Marsh, Ben Fink, and Russell Beck.
Thank you, Erica. Here in Boston, Russell Beck.
Here in Atlanta, Ben Fink.
And here in Columbus, John Marsh.
So today we're talking about the FTC's rule to ban non-competes, the first time in over 200 years that the federal government has stepped in and claimed the ability to regulate something that has historically been regulated by the states. The FTC started this process back in 2018, and it has culminated this year on April 23rd. So John and then Ben, can you fill us in on what exactly the FTC did?
Sure. Unless you live under a rock, you're probably pretty familiar with what's transpired over the course of the last 2 weeks with the FTC's decision. On, I think it was Tuesday, April 23rd, they had an open hearing in which the commissioners participated. They took a vote to decide whether they would publicly disclose the rule that they were going to propose and vote on. And then secondly, they had a vote that was accompanied by their respective positions and views on the rule. The hearing broke down along partisan lines, with the 3 Democrats voting in favor of the rule and the 2 Republicans dissenting, if you will. As Russell indicated, this has been a process long in the making. We've been following it closely. The 3 of us all provided comments among the 26,000 that the FTC entertained last year when it had announced its intention to propose a rule to ban non-competes. And the rule does just that. It purports to ban non-competes throughout the United States. It renders it retroactive. There's a carve out, a slight carve out, I guess I would describe it as, that Ben will discuss momentarily, for existing non-competes with senior executives, as that's defined under the rule. But as Russell's introduction makes clear, it's an unprecedented rule that, by the FTC's own admission, will affect potentially 30 million employment contracts around the United States.
Though I will say, John, just on that,
Mm-hmm.
I take issue with the number.
Oh, I do too.
Okay.
As you probably heard, I made sure that I cast it according to what the FTC contends. I'm skeptical of that number as well, but at least it to that point, it reinforces the monumental undertaking that the FTC has embarked upon, and the fact that it clearly intends to upset a substantial number of contracts that exist in the United States. So, Ben, this is probably as good a time as any for you to weigh in on the senior executive. I've called it a carve out. I don't know if that's the right way to describe it, but they're the only group of employees at the present time that will be bound by non-competes for some period of time.
Yeah, and before I jump into that, I have 2 questions. First, fellas, if the rule is upheld, which none of us think it will be, but if it is, do we need to be planning for retirement sooner rather than later?
To the contrary, this is companies are going to need to deal with it. It's not like employees are going to stop moving companies and stop taking information and stop taking clients, right? I mean, now we've got a much bigger problem that they're going to make these moves without the protections in place. So more people will be moving, more information and relationships are at risk. I think it's not a question of whether you need to retire. It's a question of whether you will have any minutes left in your day that you might even explore retirement.
Yeah, I'd echo that. I think, Russell, you've used the term before, the Californiation. Is that the right phrase you've used?
Californication.
I didn't want to put it in those terms, but so far as to do it, I'll accept that. But basically what this rule will do is promote a very messy, expensive, drawn out litigation, because it'll be focused on trade secret litigation. As I think all three of us would agree, those cases are they make lawyers very wealthy at the end of the day. So yeah, we're going to be gainfully employed for as long as we want to be.
All right. Well, I'm glad to hear that. That was sort of my conclusion as well, but thought I'd ask the question. But before I get to the senior executive exception, because it is a limited exception for a limited period of time, right? I do have a question for you all on the actual exception under 910(3) on existing causes of action. It says the requirements of this part 910 do not apply where a cause of action related to a non-compete clause accrued prior to the effective date. I read that to be any cause of action that has accrued regardless of whether someone's a senior executive or not. And therefore, if as of the effective date of the rule, you have a claim, then you have a claim and you don't go through the analysis on the senior executive exception. Do you all agree with that?
Yes, I do agree.
I do too. Yep.
Okay, because I had
for another 120 days.
Yeah.
Right. Yeah. Or 125, whatever the number is. When is the effective, the rule's going to come out May 7th? Is that what it is, Russell?
Yeah, the rule will post on the Federal Register on May 7th, and then September 4th will be the day it becomes effective, assuming that it's not enjoined.
Well, I'm glad you all agree with me, because I had a client, an in-house lawyer, general counsel of a client that was reading it differently and, was debating it with me. And I was trying to assure him that, what we just said was how I read it. And I think that's the right interpretation. But John, to more directly answer your question, there is this limited exception. And basically what it says is that it is the rule starts out by saying it's an unfair method of competition to enter into or attempt to enter into a non-compete, to enforce or attempt to enforce a non-compete, or represent that a worker is subject to a non-compete after the effective date. However, it does say with respect to a senior executive, it's only an unfair method of competition to enter into. So basically, following the effective date, all non-competes are prohibited. But for purposes of enforcement, the rule is basically saying with respect to senior executives, if the agreement was in effect before the effective date, you can still seek to enforce that following the effective date. And, the FTC sort of in the 500 and something pages before the actual rule sort of explains their rationale, which, like a lot of things, is not particularly helpful or persuasive, but their explanation is, well, those agreements that are existing are much more complicated to unwind than the average worker, and therefore we're going to let them remain in effect. But I think the key thing from my perspective is, how is senior executive defined? And I think that the FTC's intent, it appears, is to define it narrowly. But like most things, the rule itself, I think, can be interpreted potentially more broadly. But I think that the key point of the rule is that a senior executive has to be somebody with policy-making authority. And so I think the use of the word policy is intentional. It's not just sort of authority to do things for the company. It's actually the authority to make policy at a policy level for the company. So I think the rule specifically says people like chief executive officers and presidents are included, but there could be others who are included if they're in policy-making positions. But they have to have final authority to make policy decisions that control significant aspects of a business or a common enterprise. And so if you look at the commentary, this is around pages 268 through 275 or so. They go through all of these examples. And one of the things that struck me is that, for example, if someone is, let's say, president or CEO of a significant division of a company, that may not be enough, because the commentary at least makes it very clear that it has to be someone who controls significant aspects of the entity itself, the overall entity, not a part of the entity. I think they give some examples. For example, the chief marketing officer may have the ability to make policy or set the strategy for marketing, but that person may not have policy making authority for the organization as a whole, and therefore may not be covered. And so I think there's a lot for us to litigate here. And Russell's can't see this on the podcast. He's nodding his head, but I think there's a lot of area for disagreement on who is actually covered by this exception.
And that's an interesting point. My partner, Chris Tackett, mentioned something that I candidly hadn't thought about, and it sort of fits within the rubric of the law of unintended consequences. But this rule has the effect of making it easier to enforce non-competes against employees of small companies, because more likely than not, in a closely held corporation, an officer or really any employee is going to arguably have more policy making authority. And if I'm missing something, or let me know. But that was something that I thought was a really interesting observation.
Well, and I think John, that's a great point, and why a rule like this, when you apply it to companies that are Fortune 50 and have hundreds of thousands of employees, and you apply the same rule to a company that has 10 employees, just makes no sense. And so I think that's where these kinds of things, you're right, there's going to be inconsistent enforcement if the rule actually does take effect based on the size of the company and proving what policy-making authority actually is and who has it. So Russell, I see you nodding there.
Yeah, well, no, I completely agree with this. It's crazy. It's a one size fits all rule, and 570 pages, most of which is commentary, is inconsistent in parts, and it also is vague, despite the intended clarity. It is vague. And I'll give you another example. What about members of an LLC or partners in a partnership? Are they going to have their agreements banned, or are they not covered by the definition of worker? And I think you can find support for either position on that, within that 570-page document. So I think this is going to keep a lot of people busy for a lot of time if it goes into effect.
Yeah, we'll get to that.
Yeah, we will get to that.
the $30 million question.
Yeah. Well, I think according to them, it's the $400 billion to $480 billion question, I think.
Correct. I stand corrected once again by the magnitude of the FTC's own estimate.
And isn't that up $100 billion from their original estimate?
Yes, it is. I noticed that too.
Well, there's probably more we could talk about on that senior executive exception. The problem is it's a limited exception for a limited period of time, right? And one of the things, candidly, I've been discussing with some clients is, do you need to scramble right now to get some agreements in place that are in place before the effective date of the rule?
Yeah, but that's only going to be for the senior executives.
Correct.
And whoever they are.
Is it worth going through that analysis, particularly in a larger company, trying to figure out who would fit and then getting them under new agreements, or if they're already have existing agreements, I guess you've got them in place, but doing something now to try to be prepared for that exception to apply.
Well, I do think companies should be thinking now about what steps they would have to take if this goes into effect and when they would need to take them. So you want to be thinking about it from the standpoint of, if this goes into effect, these are the things I need to do or have done. And if it doesn't go into effect, these are the things we should be doing anyway, right? So companies should be thinking about that. But we'll get to that in a minute. I want to make sure that we first actually covered all the issues that arise from the rule.
Do we cover the salary that qualifies one as a senior executive?
No, I didn't address that because, I guess that goes to your point, John, about smaller companies, right? You could conceivably have somebody in a smaller company who is in a policy-making position, but who's making less than $151,000.
Right.
But yeah, I guess they have to be in a policy-making position and have total compensation of at least 151,164. And, I know we've talked about this. We may have even talked about it on our podcast, these arbitrary salary requirements. And I understand that states are trying to rein in the abuse of non-competes with lower wage workers. And I think that's a noble cause. But the idea that you can do it using a wage threshold, to me, it's challenging because, right, there could be somebody making $50,000 a year who does have access to trade secret information that can only be truly protected through the use of a non-compete. And so, this is more of the same on that issue. And, I think there is some explanation how they came up with that amount, but that is a part of the requirement as well.
Yeah, and you're right, Ben. We have talked about this in the past. And at this point, the takeaway is that we're going to see different states putting different wage thresholds in. They are going to be fairly arbitrary unless they're following something along the lines of whether somebody's exempt under the Fair Labor Standards Act or not exempt under that, because that at least ties a little bit to the duties of the employee, in part to the duties of the employee. But your issue about the example about someone earning $50,000 but still having access to the keys to the kingdom, the issue there, I think, is one purely of policy. We recognize that somebody at that level, earning that much money can present a real problem. But on the other hand, somebody's earning $50,000, they're really not going to be able to defend themselves from a litigation. And so we as a policy matter make the decision that we're not going to allow enforcement against them. And I understand that. And I don't have a problem with that. I think that the people in that category, I think you just are going to need to figure out how to manage through those people when you get above that.
The example I like to give, I got a biotech client, right? And they've got people that work in the lab who may be hourly workers or maybe, low salary workers or lower salary workers, but they see and learn a tremendous amount of information that is clearly trade secret information and could be very valuable to a competitor. Now, of course, if that person leaves and were to go to a competitor and convey that information, you'd have a trade secrets claim. But there's a big difference between that person and the person making sandwiches at Jimmy John's, right?
Right. But I think, look, your point is well taken. Those people do pose as significant a risk as the same person earning 3 times that amount. Yeah, right. If they're both in the same position to learn the same kind of information, to take that information to a competitor and to use that information at a competitor, which is why, again, I come back to it's just a policy decision. When people are earning this amount of money, we're not going to allow them to have non-competes. And I don't have a problem with that philosophically. I have a problem with it from a how are we then going to protect the company standpoint. But philosophically, I don't have a problem with that.
Well, Russell, let's talk about the challenges to the rule and, how likely is it that this is it's going to go into effect and or be upheld?
Can we cover one more thing, guys?
Sorry, John.
Wait, that's all right. That's all right. And I think we'll dive into this deeper when we start talking about what companies or businesses should be doing. But that's the whole functional aspect, the language that says an agreement that functions to prevent a worker from seeking or accepting work in the United States, operating a business in the United States. We might want to just highlight that briefly.
Yeah. So the fun with this rule is that nobody knows what anything means at this point. If you remember back when the FTC had done its original rule, they notice of proposed rulemaking back in January of last year, they had talked about having a functional test or a de facto non-compete test if something operates as a non-compete because it imposes significant limitations on a person's mobility, that would be considered a non-compete under the statute. They say in their commentary that they have distanced themselves from that, but the rule doesn't actually distance anything. The rule is just a rebranding of the de facto test. And the rule says that a non-compete is an agreement that prohibits somebody from competing, essentially. And if there are other agreements, for example, non-disclosure agreements being the prime example, that, because they are written very broadly, function to prevent somebody from working, then they will be treated as a non-compete under the statute. And so that could also be a non-solicitation agreement where the person is a salesperson and their ability to get a job as a salesperson at a competitor is dependent upon their ability to bring a book of business with them. Well, if you prohibit them from bringing their book of business, then is that in fact a non-compete under the functional test? We'll find out. I mean, I think there are arguments to the contrary. The commentary specifically says that your garden variety non-solicit wouldn't be. But I think that we're still going to see arguments that, no, I can't move because I'm not allowed to take the clients that I've been working with for the past 10 years. And now I've got to start all over and nobody wants me. So that's, I
When
think,
you say garden variety non-solicit, how does that impact something like a no acceptance or no service provision?
I think those are going to
It's
be
not a
gone.
general non-compete.
Well, so just to be clear on what those are for people, right? The non-solicit is the employee won't solicit customers or encourage them to leave to come and work with the employee at a new company. Non-acceptance or no service agreements are agreements where the employee doesn't solicit the customer, but they are still not able to work with the customer, even if the customer comes to them. And there are already cases that talk about those types of agreements in some states being considered non-competes. There are states that just ban those kinds of agreements independent of whether they're a non-compete. There's little question in my mind that the FTC anticipates those agreements being invalid.
Now, when you say that, invalid if it applies to all of the company's customers, or even invalid if it's limited to the customers with whom the employee had material contact or something like that?
Well, I think I think that's a great question, and we'll have to see how that plays out. I think that if you were to ask the FTC, I think they have been very circumspect on how broadly this thing is supposed to cut. And I think you're going to have to look in part at the language of the definition of what constitutes an unfair method of competition, because it talks about preventing employment or prohibiting employment, right? So that the agreement needs to operate essentially the non-compete according to the rule. If read literally, it means that it prevents somebody from taking that job, or functions to prevent somebody from taking that job. And so I think that when we look at whether, this goes straight to your question, Ben, if we look at whether the agreement really prevents somebody from taking the job or just restricts them from taking a job or limits them in the job that they can, in their ability to do the job, does that constitute a non-compete? And I think you can make arguments on both sides. When you read the commentary, the FTC is clear that they rejected terms like restrict the ability to work for a competitor. They rejected limits the ability to work for the competitor. They were really focused on preventing and prohibiting. And so, yeah, there is an argument that those types of agreements, if they're focused just on the customers that the employee worked with, would not constitute a non-compete under the statute. But I think that there will be lots of arguments to the contrary, and I think courts will come out in different ways. I mean, if you just look at Nebraska, Nebraska looks at that very issue and considers those to be non-competes.
Well, Georgia does too.
Yeah.
But the rules with respect to putting a territory on that type provision are more liberal generally. Not, well, the statute's not, but the courts have been more liberal. If you just say anywhere in the US, you won't service or accept business from a customer with whom you had material contact.
Yeah.
Generally, the courts in Georgia are going to enforce that.
Yeah. Well, we'll see whether well, what do you think? Do you agree? Do you think these are going to be banned as de facto non-competes?
I think it's a tough argument. I think it's a tough argument to your point. They left out the words restrict and limit. And so to me, does that prevent somebody or prohibit somebody from going to a competitor? In most situations, it does not. It may limit or restrict their ability to do that because, like you said, they may have a book of business they can't move. But, especially if you can prove the customers with whom they have material contact is less than 1/10 of 1% of the available market in the geographic area. So this is not prohibiting or preventing them from going to a competitor. It just means they can't take our customers with them that we paid them to develop.
Great. So let's drill down on that for a second.
Yeah, go ahead.
So prohibit or prevent. So does that mean that if I have a non-compete that says you can go work for a competitor, you can go do, let's put it in the context of lawyers just for a moment, right? Even though lawyers can't have non-competes. But my agreement with you, Ben, is that you work for me now and you're a litigator, and I'm going to tell you you can't litigate for any other law firm, but you can go ahead and do transactional work if you like. You want to go do real estate, you want to go do corporate, go for it. Is that a non-compete? It's not prohibiting you, it's just limiting you.
I love it. It's an argument that
You're going to sue me for an unfair method of competition? Is that the idea?
well, first, I'd love to come work for you, Russell, someday.
I'd love to have you, Ben. Deal. We're good.
But part of the and again, this takes us right back to the Pandora's box that's been opened here. It's very fact dependent, right? In Ben's situation, let's say it's the financial services industry. There are an awful lot of fish in the ocean for a financial consultant to pursue, but there are some industries where there are a finite number of customers, and the fewer the customers, the greater the restriction. The more likely it seems to me that you're looking at a non-solicit or non-rendering provision that could be construed as a non-compete.
Yeah, I think that's right. And that's where I think, to Russell's point at the beginning, when I asked about retirement, those are all factual issues that would have to be litigated.
One thing I want to cover real quick, guys, and I know we want to get to the chamber's litigation and what people can and should be doing now, is the NDA aspect of this, because when the proposed rule came out, that was something that really concerned me. The proposed rule, in fact, specifically mentioned non-disclosure agreements as potential de facto non-competes, and provided an example in the actual proposed rule itself, not just simply in the commentary. And while I'm loath to give any compliment to the FTC, it does appear to me that they have backed off some of the more strident overreaching as it related to non-disclosure agreements. My recollection was that in the proposed rule, there was very little empirical support. There was just simply a passing and reference discussion of what that de facto test would look like, but there was very little hard analysis or empirical support like they believe they had as it related to non-competes. I have to admit, when I went through the commentary that accompanies the final rule, there did appear to be some effort to better insulate non-disclosure agreements from being considered to be functional non-competes. And the language that made me feel a little bit more comfortable was the language that indicated that an NDA won't be a non-compete if it doesn't have prohibitions on disclosure that do not apply to information that, one, arise from the worker's general training, knowledge, skill, or experience gained on the job or otherwise, and two, is readily ascertainable to other employees. So I interpret that to mean if you have those carve-outs within your non-disclosure agreement, you're ahead of the game when it comes to arguing that you do not have a functional non-compete. Now, readily ascertainable is a pretty big exception, and I recognize that again, like we're talking about so many other things, will be fertile ground for attack. But I have to confess, I felt a little bit better about the viability of non-disclosure agreements in the unlikely event this rule is sustained.
Here's my fear, not to be the doomsayer, but the rule will be enforced by the FTC, and the FTC has its view of how broadly this rule should reach. When you look at the commentary, the FTC specifically cites to TLS management. So that's TLS management versus Rodriguez Toledo. That was a First Circuit case. And it also cites to Brown versus TGS management. That was the California case. And then it's cited to an old Fifth Circuit case that nobody pays any attention to. But it cites to these as the rule. They are the exception to the rule. And they have found that certain terms in non-disclosure agreements operate to prevent a worker from working for a competitor, working in the industry. Even though if you and I all together read these agreements, we would not interpret them that way. We'd look at them and say, no, that is not at all what these agreements meant. And so I am very concerned that an imprecisely written non-disclosure agreement, even if it was never intended to be so broad as to prevent an employee from working, will be interpreted to be a non-compete because the FTC is suggesting that these cases are the rule, the norm.
Rather than outliers, as we know
Rather
that.
than outliers. And they are 100% outliers. Ben, you think otherwise? You're going to split the difference between me and John, or?
Yeah, honestly,
The
fellas,
optimist and the pessimist.
Ben will be the realist.
The doomsayer and
I've not had the chance to study that issue yet, so I'll defer to you. I know, Russell, we've talked before about those decisions being outliers, and it's just another example of where they, sort of cherry picked the rationale for the rule.
So the one other thing that we haven't discussed about the rule that I think it's important to cover is that the rule requires employers to provide notice to any employee, current or former, that has a non-compete agreement that would violate the rule. And so they're supposed to provide that notice by the effective date. That is 120 days after within 120 days after the rule is published on the Federal Register. That notice, fortunately, is fairly straightforward. There's actually an example of language that would satisfy the rule if you copy it. It's right in the rule. They have addressed a number of the issues that we saw with the California rollout. There were questions about, can this go by email? Does it have to go by hand? What's the date that it has to go by? Does it have to be received by Valentine's Day, or can it be sent on Valentine's Day? All those kinds of questions. Do you have to identify the specific provisions in the agreement? Those kinds of questions have all been addressed. We now know exactly what the notice needs to say, and we know where it needs to go. It goes to email, it can go by hand, it can go to their address. But if you don't have addresses or emails or whatever, that's okay. And, basically the FTC is saying, do your best, and which is a little bit different from what the California law said to do. So that notice, I think companies need to be prepared for that, because if the rule does ultimately go into effect, it's not like once it goes into effect, you've got a bunch of time. You need to have done this by the time it goes into effect. So now, should we turn to the challenges to see, will the rule go into effect? I'm going to cover those just very quickly. I don't think the specifics matter all that much. I think the top line here is that there are currently 3 actions pending to challenge the rule, to say that the rule is outside the authority of the FTC. It was arbitrary and capricious. It has impermissible retroactivity or retroactive effect. And those challenges are pending in the Northern District of Texas. That was brought by Ryan LLC. That is a company that is a global tax advising company. That was brought the day the rule was announced. There's an action brought by the U.S. Chamber of Commerce, the Texas Business Association, I think, and then 2 other Texas associations. That was brought the following day. That was brought in Tyler, Texas, which is the Eastern District of Texas. And then a day or 2 later, there was an action brought by, I think the name is ATS Tree Services. And that oddly was brought in the Eastern District of Pennsylvania, which I understand that that's where the company is located. So they would bring it there. But that seems like an odd choice for a venue to try to invalidate a rule. So we'll see.
Better than California, don't you think?
That I think that's fair. That it is better than California. But I think, Florida, Texas, Arizona, there are a lot of states where I might have gone before going
I would tend to agree with
Pennsylvania. So, I think the challenge is, essentially, again, it's that it's outside the authority of the FTC to regulate in this area, and that even if it was within their authority, that Congress was not allowed to give them that authority because this is too significant an issue. It's called a major questions doctrine. And that one is really interesting because for the FTC to say, hey, look, we can regulate in this area because, you can read it into the rule. I think the saying is, for these kinds of cases, they say, are you trying to pull an elephant out of a mouse hole? I think is the lingo for these types of cases. And so the FTC says, look, you can read this to give us, and we do read it, to give us rulemaking authority for these types of things. Well, the problem is that Congress could not have given them authority to regulate something that has, according to them, $400 to $480 billion of impact, something that Congress has already tried to legislate over since 2015. And so the idea that the FTC can just step in and replace Congress for something like this, I think, is probably the clearest example of why this rule is outside the scope of the FTC's authority.
Russell, before we jumped on, I was commenting about your blog post that indicates the court has asked for briefing on sort of the scope of any relief that it could award in the case. And the FTC is arguing that it will be limited to the members of the organizations that have sued. And I'm just, you and I were talking about it. Is there some risk that if there's an injunction, it only applies to companies that are members of the U.S. Chamber and those other entities that are organizations that are plaintiffs?
Yes, that's such an interesting question, right? Normally, the kinds of cases we deal with, it is private parties litigating over whatever obligations somebody may have had, whether it's B2B or an employee's obligations and their conduct or misconduct. But here we're dealing with a federal agency. And so there is a concern that the only people who can benefit from the ruling, and this is certainly the FTC's argument, are people who are identified as parties to the action. And so not just the U.S. Chamber of Commerce, but disclosed members of the U.S. Chamber of Commerce and the other plaintiff organizations. So there are lots of questions around whether the FTC is right on that or not. We have not yet seen the briefing from the chamber and the other associations. I expect that they will take issue with that. I certainly have a problem with that. To me, this is not a question of the application of the rule to these parties. It is a question of the FTC's authority to issue the rule in the first place. And so if the court, presumably the one that's farthest along, if that action results in an injunction against the FTC, that injunction is going to say, FTC, you may not enforce this rule. It was in excess of your authority. So it's not, you may not enforce this rule. It shouldn't be. You may not enforce it against the Chamber of Commerce, whether disclosed or undisclosed members, but you can't enforce it at all. And that, I think that's an open question. I think we'll have to see. Briefing on that should be coming soon. So stay tuned.
I'm looking now at the complaint that the chamber filed, and while the counts are all styled as arising under the Administrative Procedure Act, the APA, they do have in their prayer for relief a declaratory judgment. So I wonder whether, recognizing that an injunction may be limited to the parties that are there, but a declaration that the rule is arbitrary, capricious, or otherwise contrary to the law under the APA may at least have some collateral benefit for those that aren't members of the chamber, disclosed members of the chamber, if you will, or Ryan.
Well, and Ryan is a disclosed member of the chamber.
Are we expecting other challenges? I was a little surprised that, I know we had been hearing all along the U.S. Chamber was going to challenge it. I hadn't really heard of other organizations or companies. I'm a little surprised there haven't been others.
Yeah, that's a great question. I've heard of one other company that was planning on suing. I haven't seen that happen yet. But first of all, if I were a company, I would not want to be the one running out and suing the FTC because you're just putting a target on your back. The other is because don't forget, they'll still be able to do enforcement actions, right? They can still separately bring actions as they did before they issued the notice of proposed rulemaking. So if I were a company at this point, or even an association at this point, I would do exactly what you're saying. I would do the wait and see. There's still plenty of time
Now, I agree with you, Russell. Why in your right mind why would you bring your own action? Why put the target on your back, as you say?
Ben, you think otherwise?
No, I think that makes sense. I think that is likely what's going on, and that's where I just don't know enough about how an associational lawsuit like the U.S. Chamber has brought works, because I've never litigated that. Obviously, it's foreign to our practice.
Yeah, for sure. So why don't we turn to the practical advice that we're giving to clients and others at this point? What do you guys recommend? What do you tell people?
Right now, it's just wait and see. At least for a couple of months. Like you said, Russell, where it's going to get a little dicey is if we get into July, mid-July, late July. If there's no ruling, then companies are really going to start bumping up against having to at least start preparing to provide the notices, because especially for larger companies, that's not going to be something that can be done in a week or two. And so, to me, that's going to be the bigger issue. But for now, I think it's still just wait and see. Of course, like we've been talking about on this podcast and all of our other venues or forum, is doing all the other things you need to do to prepare for a day when non-competes may not be enforceable, whether it's through congressional action or through the states and what's going on in the various states by tightening up your confidentiality agreements and your other covenants to protect yourself as best as possible, even if you're not allowed to use a non-compete.
I think that's right. I would definitely make sure that all of my agreements are as tight as possible, and not just thinking about the FTC rule, but also thinking about the state laws now that have become much more strict than they have in the past. There are still bills pending around the country, a lot of bills. I think there were 72 at the beginning of the year, or somewhere, a month or two ago. And I think we're down to somewhere in the mid 60s at this point. So one bill passed, that was the Washington bill. But I say Washington State, and that has an effective date of June 6th. And it basically says that it expands what a non-compete is to include effectively no service agreements. There are other things that it does that people need to comply with. So I would, at this point, take the opportunity to make sure that all of my agreements are compliant with all existing laws and are as narrow as possible, so that if the FTC rule comes into place, not only am I compliance with the other state laws, but I'm also in compliance with the FTC. I would not, however, pull the trigger on removing non-compete agreements from my agreements at this point. I would wait until we see what happens with the FTC, with the challenges to the FTC's rule. At that point,
Yeah, but one conversation I have been having with clients, because we were in the midst of a project for a couple of projects for a couple of clients and revising their agreements, is, as a practical matter, because this has gotten attention in the mainstream press, everybody knows about it. And so if you roll out new agreements now that have non-competes, I think employees are going to react in one of a couple of ways, right? They're going to say, I'll just sign this thing, they're not enforceable anyway. Or they're going to say, wait a minute, why are you asking me to sign a non-compete when the federal government just said these things are illegal? So I think there are challenges as a practical matter in sort of continuing with business as usual, particularly if it means asking people to sign new agreements that contain non-competes.
So I agree. I mean, you're going to hear that from the employees, but on the other hand, that's not what the law is. So
Sure.
So I think the message to employees is, look, the FTC's rule, if it goes into effect, may invalidate these, and we recognize that. But we still need to protect our information, and we need to protect our customer relationships and our workforce. And so until the FTC rule goes into effect, this is business as usual. And we're trying to make our agreements as narrow as possible. In fact, that's one of the benefits. The FTC, I am sure, as part of its goal, was to get this out to the public and to make the workers who might not have otherwise been aware of the impacts of non-competes be aware of them. Hey, look at your agreements and make sure that you don't have one of these types of agreements. And I think that it has served that purpose already. To your point, Ben, you had to be under a rock to not know that what the FTC has done. So I think that while there may still be some people who are under a rock, I mean, we live and breathe this, so we see it all, we know what's going on. There may be other people who really legitimately aren't paying attention to it. But I do think that to the extent that people are aware, they at least know to look. And the other thing is, I've always thought that companies should allow employees to try to negotiate these. If an employee comes to you and says, "Look, I don't think that I should have a non-compete for X, Y, or Z reason," or "I think that the non-compete you're asking me to sign is overly broad for X, Y, or Z reason." I've always thought that companies should say, okay, let me take that into account and decide, because there may be circumstances that are unique to a particular person or a particular role at a particular time that might warrant a change to this language that's in the agreements. So that's,
Yeah, I think the challenge with that has always been that, or not always, certainly in the last 15 to 20 years, that companies are just so paranoid of doing anything different for any individual, right? They've been so well trained by our fellow employment lawyers who do more traditional employment type work that any exceptions you make leave you exposed to claims of discrimination and disparate treatment and things of that nature. And so I agree with you, Russell, but again, as a practical matter, I think that's hard, particularly for the larger organizations.
yeah, no, I recognize that that can be difficult, but if you think about it from the framework of narrow your agreements as much as possible, narrow who gets them as much as possible, who get the particular restrictions, right? So everybody virtually, if not everybody actually, who is an employee of a company should have a non-disclosure agreement. There are very few people who that doesn't apply to. Then who should have a no recruit agreement? Who should have a non-solicitation agreement? Who should have a non-compete? And make those choices based on what you really need, not based on, well, I may as well have one, like people used to do in the past. And so I think that is one of the benefits of the FTC's rule. I think it's one of the benefits of the legislation and all the press that's been out there. The companies are thinking a little more carefully about who they're using these agreements for and what they say. So I think that's all good, and companies should continue to do that. Take this as an opportunity to just double check everything. Check your policies too, because the policies now are considered to be non-competes under the FTC's rule, as well as under, I know the DC, Washington, DC, will consider a policy that violates the rule to be a non-compete for those purposes. And so other states are looking at that. And so I think you really need to be careful on the policy side as well. The other thing that I think is critically important is, we're focused on we're talking about all the documents right now, agreements and policies. But the other thing for companies to be very careful about and to really be focusing on right now is, what are the protections that you have in place to prevent any sort of data loss or customer loss in the first place. So that means looking at the practices that you have to make sure that only people who need to know information or have access to that information. Those kinds of things, training your employees, making sure, like on the way in, that they understand before they even leave their prior company that they shouldn't be taking any information. And then when they get to the company, they need to make sure that they understand what it means to not bring or use or disclose any information at the new job. Train them during employment, train them on the way out. And, the training on the way out is a little bit different because it's not a true training, but it is the kind of thing where you want to make clear to people, these are our expectations, and have that dialogue with them, whether in an exit interview or otherwise. So those are the kinds of things. There are a lot of details around each of those stages. And I know any of the three of us would be happy to discuss that with anybody who has any questions. But I do think that these are critically important things to be focused on right now, irrespective of whether the FTC rule goes into effect, and even more so if it does go into effect. All right, well, this was a very productive conversation. I think it'll be very helpful for our audience. We are all, I know, available to answer the many questions that I am sure people have, but I think this was a great primer. Thank you both for walking us through all of that. I think it was terrific.
I agree. Thank you, Russell.
Yeah, thanks, fellas. I think it was a very good discussion. We're living in interesting times.
That we are. So stay tuned.
That concludes today's show. You can visit the official podcast website at fairlycompeting.com. And please note that this show is provided for informational purposes only. None of your hosts is providing legal advice, and your use of this podcast does not create an attorney-client relationship in any respect. Thank you all for joining us.